Hey class, Mr. Stewart. This is going to be your integrity video for week 3 for chapters 5 and 6 in the textbook. I'm sorry for getting this posted late this week. It seems like this week has been really hectic, and for some reason I just didn't get around to getting this up here until today. But nevertheless, I'll try to be earlier than this from this point forward. So with that being said, this week you are tasked with reading chapter 5 and chapter 6 in your textbook. I'm going to hit a few high points in both of these chapters here over the next 10 or 12 minutes in the integrity video. And, just understand, these videos are not to be done in lieu of reading your textbook. In an online class, you have to read the book and you have to kind of dig some for yourself. But it's my job to help make that job a little bit easier by maybe clearing up some of that muddy water for you with these videos. And as always, feel free to reach out to me. I'm here for you to answer any questions. Okay, let's get started. Chapter 5, the law of corrections. And really this is important to understand, because you really have to understand what allows a government agency to take the body of a convicted criminal and keep them in a prison cell for a period of time, and then what they can do with that person while they're in prison, and then what can be done with that person after imprisonment or after release of prison, and kind of what goes along with that. So it's really important, because we're actually, when we incarcerate somebody, we are violating their rights. But we basically have a court order to violate their rights, and we do it via statute or via law because they are a criminal. But just understand, we're still violating their basic human rights by taking away their freedom. So this chapter really discusses the foundations that support legal rights of prisoners. It looks at the role of the Supreme Court in interpreting corrections law. It looks at the constitutional rights of prisoners. It's going to ask you to be familiar with alternatives to litigation, or basic alternatives to suing, explain the rights of offenders under community supervision, and discuss how the law affects correctional personnel. So the best thing I can tell you here is that as a correctional professional, go by the law. If you don't go by the law, you are setting yourself and your agency up to be sued and probably lose. Out of the 6 times that I have been sued throughout my career, I think 4 or 5 out of the 6 times were when I was stemmed from when I was employed in corrections, because inmates are sued happy as well as their families. So if you don't do something that they think is correct, they will file a lawsuit. They have plenty of time to do so. So it's important you understand what your limits and constraints are, as well as what the inmates' constraints are, and understand kind of that legal foundation of this whole idea of corrections. So this first objective looks at the foundations that support legal rights of prisoners, and which means where do we get the law that we have to follow in regard to prisoners? Well, the Constitution is one that provides a framework, some basic principles, and some safeguards. We have statutes, which are laws passed by the legislature at state and federal levels of government. That's much more specific than the constitutional framework. It kind of fills in the gaps. We also have case law, and what case law is during previous court decisions, we don't have to go back and reinvent the wheel in regard to a current court case. We can look at what previous courts have done in similar cases in the past, and if that is applicable now, then we can use that court decision without having to reinvent the wheel. And then we also get law from regulations, and this is called administrative law. Honestly, it's not really law, but it just carries the same force and authority as law does, but it's just simply regulations made by a particular agency, such as a Department of Correction. It's rules made by an agency such as the Department of Correction or some other federal agency. So these are the 4 foundations that support the legal rights of prisoners. This is where those legal rights come from, these 4 sources, which also is the 4 sources of criminal law in our country. So these next several slides just basically go through and they talk about the Constitution. They talk about the statutes, the case law, and the regulations. So please make sure you read that. It's pretty straightforward. Just understand that those are the sources or foundations of law and inmates' rights. Now, you need to also understand that the Supreme Court interprets the law. That's what any judicial branch does, is they look at the law and they interpret it. And depending upon the judges that are on the Supreme Court, they may interpret the law different than a previous or a future Supreme Court will. That's why they change from time to time. And the judges should be representative of the people. I don't think they always are, but they should be. And as such, they should be using the interpretation of the law that is most applicable in the contemporary time period that they're operating in. For many years, the U.S. Supreme Court kind of had a hands-off policy in regard to how prisons were ran. They pretty well left it up to the state and the federal government to run prisons any way they saw fit. The Supreme Court was very reluctant in putting their finger into the pot of soup and stirring it in regard to how states were running prisons. It was only after things got brought to the attention of the Supreme Court that some states were not treating their prisoners correctly or they weren't giving them basic human rights that the court began to reconsider that hands-off policy and look at doing some things to make sure that the prisoners' rights were also being protected. And so this is a court case here, Ruffin versus Commonwealth, basically said that there should be a separation of powers between corrections and the courts, and that the prisoners didn't have any rights. So as of 1871, and when you went to prison, you were basically property of the state, and you didn't get to do anything unless they said so. You didn't have any rights other than what they gave you. This really didn't end until the 1960s, so almost 80 years or so of this kind of hands-off policy. But in the 1960s, we started having a much more liberal political Supreme Court, and they began looking at protecting basic human rights. And that's one of the good things that came out of having a liberal Supreme Court was they began to protect everyone's rights, not just criminals, not just non-criminals. They were really looking at protecting everyone's civil rights, and they went back to another law that was passed in 1871 called the Civil Rights Act, Section 1983. That has nothing. The 1983 has nothing to do with the year, by the way. And basically, it says there is a responsibility for the provision of monetary or other compensation awarded to a plaintiff in a civil action. So if you got sued after 1871 and you lost your case, you may have to pay money damages to the person that sued you, that you caused harm to. And so we began to see in the 1960s, with the ending of this hands-off policy, that prisoners started suing departments of correction left and right for what they believed to be perceived, and some of them were real, injustices, violations of their rights. And what we saw as the courts began to find in favor of the inmate, which caused the state departments of correction, state governments, and even individual corrections officers to have to pay loads and loads of money to these inmates and their families because they had not been treated correctly in the prison. So that's when all that started, was in the early 1960s. Please read that section in regard to habeas corpus, in regard to prisoners' access to courts. I think that's an important part you need to understand in regard to how the Supreme Court has ruled in regard to whether a state is holding someone unlawfully or whether or not an inmate has certain access to the court system. Prior to some of those court cases, the access was very limited. Now it's not limited so much. Learns Chapter 3 asks us to understand the constitutional rights of prisoners. And basically, we look at the interest of the state to protect the public from these inmates, that takes precedence over rights that have been guaranteed by any of the other amendments. So basically, there's a compelling state interest to sometimes limit the rights of inmates. And I think we can understand that if it goes toward protecting the public so that these people don't either verbally or physically harm other people while they're being incarcerated, then we don't mind asking them or taking some of their rights from them, ask them to give up their rights or taking some. However, it should be the least restrictive method, and that means that's a means of ensuring a legitimate state interest that imposes fewer limits to prisoners' rights than do alternate means of securing that end. So we have the compelling state interest to protect the public, but when we do it, we should be using the least restrictive method necessary in order to do that. Next slide goes on and talks about that clear and present danger in regard to constitutional rights of inmates. You can read that. That's pretty straightforward. We also look at how we go about determining if an inmate's rights have been violated using that rational basis test. It talks about some of the constitutional rights of inmates here. The First Amendment in regard to freedom of speech, the Fourth Amendment in regard to unreasonable searches. You won't find many of those in prison. Most searches that occur in prison are considered completely reasonable. And even if you have been released from prison and you're on parole, you can still be searched and not having had all of your Fourth Amendment rights restored to you at that point. The Eighth Amendment's in regard to cruel and unusual punishment. This is a right inmates do have. We have the right to punish, but we cannot punish them with cruel or unusual punishment. And what makes punishment cruel or unusual? Whether it shocks the conscience of a civilized society, is it unnecessarily cruel, or it goes beyond legitimate penal aims at rehabilitation or legitimate punishment. If it goes toward somebody that just wants to be mean and nasty to somebody because they get off on it, that would be a violation of the inmate's right, for sure. There's a couple court cases there. It's mentioned in your text. You can read those. I think you'll find those to be pretty interesting and applicable as well. And then basically, how do we go about determining if inmates' rights have been violated? We use what's called a totality of the conditions or totality of the circumstances test. You can read about that. Inmates also have the right to due process, which means if you charge them with a rule violation or a crime inside the prison, they are still entitled to that fundamental fairness to go through the system the same way they went to before they got there. Doesn't matter who they are or what their crime is. They still have due process and equal protection under the law. Talks about procedures for disciplinary actions of inmates. That's very important. If you work in a prison, you can't just discipline the inmate any way you see fit. You have to do it a certain way. Learning Objective 4 asks you to be familiar with alternatives to litigation, and that's basically alternatives to suing someone. So it gives you some of those alternatives, such as filing a grievance, using an outside person to help investigate a complaint, going through mediation, or even requesting legal assistance. Typically, we see all of these in most prison facilities. We see people who act as the ombudsperson, somebody who can come in and be a mediator between prison inmate groups and staff on occasion to get things done or accomplished. So all of these things are designed to solve problems before an inmate feels compelled to actually file a lawsuit, because filing a lawsuit costs a lot of money. It costs money to the state because the inmate probably cannot afford their own attorney. So the state ends up having to pay those legal costs as well as their own to dispute whatever the claims made in the lawsuit. And then, of course, if the state loses, it's very expensive. that they're going to have to pay a lot of money out to an inmate or an inmate's family if they lose that lawsuit. So they will try to use these alternatives to litigation as much as possible. Learning Objective 5 here is asking you to explain the rights of offenders under community supervision. And understand that you don't have a right to parole. We will parole inmates out based upon overcrowding or other issues within the prison, but you don't have a right to that. They can hold you for your whole sentence. However, if we give you parole and then we decide that you're not living up to the rules and regulations of the parole, then you are entitled to a hearing, and you also are entitled to due process to determine whether we're going to violate that parole and put you back in prison or not. Typically, there's a two-step process in regard to the hearing to revoke someone's parole, to basically have them rearrested, recharged, and reincarcerated. Hearing officer has to determine that there's probable cause that a violation occurred, and then the parolee must receive the notice of charges and the disclosed evidence of the violation. So basically, it's just like they were going through a mini trial for the reason that they violated their parole again. They have the right to speak on their own behalf. They can cross-examine witnesses and try to poke holes in people's story the same way their defense attorney could have when they were on trial the first time. But you know, it sounds like it's complex, but it works, and it works pretty well. Because typically, if you violate somebody's parole, you don't appeal that and find that your parole was violated unconstitutionally or illegally or something like that. So just understand that they go through these processes, and you'll learn these processes if you work in parole in order to make sure that everybody's rights are protected. Then I think the last objective here is discuss how the law affects correctional personnel. The law sets forth in most states how we go about hiring, promoting, assigning jobs, disciplining, and firing or terminating personnel that work in prisons. Typically, that's usually a civil service job. When I worked for Tennessee Department of Correction, you were on probation for a year. After you got off probation, you owned your job title. And even if you quit, you still own that job title. You can bump anybody at any time for that particular job, working as a corrections officer, not the actual job assignment, but working as a correctional officer. If you own your job title, you own it forever unless they take it away from you. So you can, even if you quit and you want to go back later, you can. I knew a guy that did that. So the law is very specific in most states on how civil service job positions work. In many cases, they're unionized, which allows for the use of collective bargaining, and also in case grievances or disciplinaries are filed against employees, then the union will typically represent that employee as well. Just understand, as a corrections personnel, you cannot deprive others of their constitutional rights while acting as an official, in an official capacity. Very few of these cases go to trial, and very few correctional employees personally pay financial awards to plaintiffs, but in many cases the prison or the state will have to pay rewards if one of their employees is intentionally depriving someone of their rights. I remember working in DOC, and we had an inmate, and I can't remember what his real name was, but he wanted to be called Shabazz. He had converted to Islam, and he wanted to be called Shabazz. Well, that wasn't his name on my roster, and so I did not call him Shabazz. I called him inmate, whatever his last name was. I think it was Washington. Well, he filed a grievance against me for not saying that I was intentionally depriving him of his right to practice his religion by not calling him by his religious name. And believe it or not, the prison sided with the inmate. They said, well, he does want to be called Shabazz, and that's due to his conversion to Islam. So on all official paperwork, he'll still be known as inmate whatever, but when you address this inmate, you need to address him as inmate Shabazz. So I'm like, okay, that's what you say, that's what I'll do. And so, he wasn't trying to get money out of it, he just wanted to be called Shabazz. I guess if I went to the trouble of changing my name to Shabazz, I'd want to be called Shabazz too. But that's just an example of how that works. You also have liability issues when you work in a prison situation. You might want to read those court cases as to what you can do and what can get you sued, and what's unacceptable behavior, and the culpability of correctional personnel in those cases. So please read that section. And that's all I wanted to cover out of chapter 5. I want to talk about chapter 6 here for a minute. That has to do with the correctional client. And I'm not going to go real deep into this because it's really straightforward and you can read it, but I think it's important to talk about a couple different things. But I want to go to these learning objectives first in regard to this chapter. You should, by the time you get through this chapter, you should understand how the criminal justice system operates as a large selection process to determine who ends up in the corrections system. You should be able to describe some of the similarities among and differences between the general population and people who end up under correctional authority, and identify the different types of offenders in the corrections system as well. You should also be able to describe the classification process and understand important problems and limitations in classifying people under correctional authority. So, just understand that it actually is fairly hard to go to prison in this country. You have to really try to go to prison. Out of every 1,000 crimes that happen, only about 500 are reported. And out of those 500 that are reported, probably 25 to 30 people go to prison for every 500 reported crimes. That's really not a very high percentage. But just understand that we reserve prison for the most severe criminals and the people who've been convicted of the most heinous crimes. We don't send people to prison for writing a bad check. Typically, you go to prison, you got people in there for bank robbery, murder, assault, rape, child molestation. The worst that our society has to offer usually ends up in prison. So honestly, the way our justice system works, it is really just a selection process. That if you meet certain criteria and you've committed certain crimes, the likelihood you'll go to prison is greater than if you didn't meet that criteria or had not engaged in as serious of a crime. So you can read how that selection process works, but in a nutshell, that's really what it is. Understand there's also a difference between people who are in prison and people who don't go to prison. The majority of people who end up in prison also have a higher amount of, or a higher incidence of mental illness than the general population out in the free world does. We also tend to send more African American people to prison than any other race or ethnicity. Some people say that's due to discrimination. Other people say it's due to that just happens to be the particular race or ethnicity that is committing the lion's share of crimes. And honestly, there is research that can point to both of those as being somewhat correct. So, we do know that African Americans are definitely overrepresented in prisons in regard to their incidence in the general population out in the free world. We also send more poor people to prison too. Why do you think that is? Probably because they don't have the money to buy a really good attorney who will work really hard to get them something less than a prison sentence. And it's bad to say that the richer you are, the least likely you are to go to prison. But unless you commit first-degree murder, that's kind of the way it works. Because if you have enough money to buy a really good attorney, that really good attorney has lots of tricks up his sleeve. They can do certain things, and they can work out deals for you so that you don't have to go to prison. You may still be punished in some shape, form, or fashion, but you could probably avoid a long prison sentence unless you commit first-degree murder. So, offenders do share a lot of similar characteristics, but they also have lots of differences as well, and you can read about that. Different types of offenders in the correction system. You're going to have white-collar people, you're going to have elderly people, you're going to have mentally ill people, young people, people from all different races, ethnicities, religions. I mean, really and truly, other than telling you that African Americans are overrepresented in the prison population, any type of person you can encounter out here in the free world, you're going to encounter in prison too. So, and they all pose special issues and problems for staff and officers and such. It just depends. I mean, there's really no real way to generalize that, other than the fact that you run into all kinds in prison the same way you run into all kinds outside of prison. And I want to, your book goes in and talks about situational offenders, some of their issues, career criminals, some of their issues, sex offenders, some of their issues, substance abusers, some of their issues, mentally ill offenders, their issues, AIDS offenders, are basically offenders with AIDS. Unfortunately, now we used to kind of separate inmates with AIDS from the rest of the general population in order to try to prevent the spread of the disease. However, the Supreme Court now says we cannot discriminate against them because of a medical condition. Alabama used to have every one of their inmates from the whole state that had HIV or AIDS in one cell block at Limestone Correctional Facility right here in North Alabama. Now that has since changed. They could be anywhere at any prison facility, which poses a definite special risk for other inmates and staff as well. So it's an issue. It's a problem we're having to deal with. Many states have HIV testing policies. Some don't. Some only test if you're high risk. Some only test you if the inmate requests it, and some can request testing if you're high risk or low risk. So it just depends. It also talks about the elderly offender, some of their issues, the inmate that stays in for a long period of time. Make sure you read what it says about institutionalization or prisonization, because it changes who that person is and their dependence. You've been in prison for a long time, you become dependent upon the rigor and the structure, if you will, the rigid structure of the prison system. And if you let them out, they have issues actually trying to make it out in the free world. And then Learn Objective 4 asks you to describe the classification process. What the classification process is simply where we determine which prison to send somebody to based upon the crime they committed, what their security level is. Also, we consider their needs, educational needs, medical needs, family, where their family is located in the state. Do we want to put them on the other end of the state than their family, so it makes it a burden to visit and all that good stuff? Just understand that with the nature of classification, institutional security will override all personal wants, needs, and desires. It doesn't matter if you need a whole laundry list of services to be provided by the Department of Correction. When you come into prison, if they deem that you are a dangerous offender and you need to be held in a higher security complex that doesn't offer the services that you need, they're not going to worry about offering you the services that you need until such time as they have classified you and you have spent some time at a high enough security level that you don't pose a danger to yourself, other inmates, or staff. So institutional security overrides any personal wants, needs, or desires in regard to the inmate and how they're classified. So this slide and your book goes into specifics on how we do classification. You can read that. I think you'll find it pretty interesting. But it will tell you that one of the overriding factors is institutional security and protecting the public from that inmate. This also talks about some of the problems and limitations in classification, which some of the things I just talked about. Also talks about a few other things. So make sure you read that section as well. Both of these chapters are pretty well straightforward. Again, reach out if you need anything, and I will get next week's Integrity lecture uploaded prior to Thursday morning. I promise. Have a good week, guys. I'll see you in discussion boards. Bye-bye.